Hi, I'm Christy Davis, MetroTech's Forms and Contracts Committee, and today we've got Charles Kramer with us, the co-chair of the Broker Lawyer Committee, to discuss with us the HOA addendum, paragraph C, and the condo contract version of the same component. Hi, Charles. Thanks for joining us today. We so appreciate it.
How are you?
I'm good. I'm good. So let's just dive in and talk about what were the changes, what the Broker Lawyer Committee was intending to do with the change to help simplify this. So I'm just going to let you take over for a moment.
Okay, so we'll talk the HOA addendum first. In the HOA addendum, there used to be a paragraph D that's been kind of removed and renamed, but it had this line called deposits for reserves. And it basically said that if something was a deposit or a reserve, that it was always buyer's expense. And then it would allocate the rest of the costs in the old paragraph C according to some buyer cap. Now, why did we need to change it at all? The problem was HOA fees over the last 5 or 10 years have multiplied, and they have many different names, and it got harder and harder for agents and title escrow personnel to determine whether something was a reserve or not. Is that a deposit for a reserve, or is that some other fee? Because there would be maybe a dozen or more different named fees. You'd ask what they were for. Sometimes you would get good answers, sometimes you wouldn't. And because of this, you got a lot of arguments at closing as to whether that fell into paragraph D, which would be a buyer's cost, or whether it fell into the budget under paragraph C. And to simply eliminate arguments and to allow the parties to freely negotiate who would pay what, the Broker Lawyer Committee said, let's forget these artificial distinctions of whether something's a reserve or not a reserve, and just say, you know what, other than the cost of the resale certificate, we're going to let the parties bargain between themselves on everything, on all fees. So they just threw everything into one basket and said, all fees associated with the transfer of the property shall be paid by, and it has a buyer cap. And that's the thing that has caused a lot of hue and cry in 2021, is because in most parts of this state, we're in a seller's market. So this is not a thing that sellers like. They don't like receiving word at closing that they have to absorb a great number of costs, because tradition has been for that buyer cap to be set relatively low. But it doesn't have to be that way. You can certainly, if our market changes and this becomes a strong buyer's market 3 or 4 years down the road, then the buyer's cap is great. Everyone is happy to say buyer won't pay more than $300 and seller will pay the rest. And that's what we're in a seller's market, so sellers hate that. So we have to understand how the cap works and make it work to our advantage. Perhaps the best way, or one of the ways you could use it, is you could say, look, if you don't want the seller to pay for anything and you want the buyer to pay for everything, then you could make the cap it's so ridiculously high that it would guarantee that buyer would absorb all costs. You could have a seller write in there $10,000, and that would make the buyer pay for every HOA cost of every kind, or have some high number, maybe 5,000 if I don't really know what DFW HOAs what their max fees can run, but they're much higher in the South Texas and Houston area. So you could set that really, really high, and you could have the buyer end up paying for everything, because it's just a not to exceed, it's a budget or a cap. Another trick you could do in a seller's market that might make agents and sellers more happy, since they often don't know what these fees are, is to reverse the polarity of the fees. And here's what I mean by that. This is currently a buyer cap. Well, if your client requests it, agents often feel they can't change anything in the boilerplate of the contract. That's true on their own. They're not allowed to practice law, but they are allowed to be a scribe and to do whatever their clients want. So if their clients are informed and understand this, and maybe their clients talk with an attorney who says reverse the cap, you could, as an agent, if your client instructed you in writing to wherever it said buyer, you would change that to seller. So you would say, The language would read something like this: except as provided in paragraphs A and D, seller shall pay any and all association fees, deposits, reserves, and other charges associated with the transfer not to exceed $150, and buyer shall pay any excess. So you're simply changing that so that instead of a buyer cap on those fees, it is in fact a seller cap. Again, this is a temporary market. I know agents don't think that, but when you look over a period of 20, 25, 30 years, we have strong sellers markets, we have buyers markets. These contracts are written, they're attempted to be written to be fairly neutral, but in a seller's market, a buyer cap on this can feel hard and unfair. And so you've got to address it in some way and understand what it says and means.
Right. And maybe another best practice, I know we did this years ago and we've kind of fallen out just because sometimes our properties were staying on market longer, is maybe have the seller go ahead and order the resale certificate so that they know what the costs are up front. Correct. And they have a better opportunity to negotiate during the contracting phrase or offering phrases of these situations.
I wish more sellers would do that. You know, we're in a world where sellers don't feel they have to do anything because they're so powerful, and I understand the sentiment. But if you as a seller will go ahead and spend that money and get all of the fees assembled and get that complete resale package, even though it has a shelf life, you can do something amazing. You could supply it to an offeror, you know, let's say your main one, and you go into paragraph A of the mandatory HOA addendum and you check box 4 that says buyer doesn't require it. Why not? Because I've already been given a complete package. I've looked at it before I've signed the contract, and you get rid of that little 3-day option period, so to speak, in paragraph A. That's a wonderful thing to close that loophole as a seller. So folks, spend the money if you got it. You know, try to go ahead and get those packages ahead of time so you can get that waiver of that resale review by the buyer.
Yep. And Charles, most of the time, those resale certificates, that complete packages, is good for up to 3 months. Is that accurate?
90 days. And then there is this thing called an update where you can get them updated for a lesser fee than a complete new resale certificate. But beyond about 180 days, I mean, if you're on the market for more than that, you're probably going to have to get a new one. So I understand the hesitancy, but the benefits that accrue in knowing what the charges are, in being able to get your buyer to waive those termination rights, really do, I think it makes it worth the cost of the seller.
Yeah, definitely. I would agree with you. So now let's switch gears and move over to the condo contract. Sure. And just address kind of the little nuanced differences with the condo contract.
Well, it's virtually the same change. And so basically the language in paragraph 12A3 was modified to, again, take out there used to be a paragraph 12A4 that said buyer shall pay any deposits for reserves required by the condo association. Got rid of it because, again, there are all these names for these different charges, and maybe they're for reserves and maybe they're not, and maybe you can get a straight answer from the condo association and maybe you can't. And even if you did, you still had arguing at the closing table as to whether that was a deposit or not and subject to the cap or not. So they're all lumped into one pile, just like the HOA. And so it basically says buyer shall pay any and all association fees, deposits, reserves, and other charges resulting from the transfer of the property not to exceed blank. Again, we have a buyer cap, which works fine in a normal market, but really bothers people in a seller's market. So the very same concepts I spoke of with the mandatory HOA addendum can be used. If you're in a seller's market and you don't want, as a seller, to pay a bunch of these charges, you can either reverse the polarity of the language and make it a seller cap on expenses, or you could put a huge number in there to make sure that buyer paid for everything. Again, I would suggest maybe 10 grand. That would certainly take care of everything in the 9 or 10 county North Texas area. So I would deal with it the same way and understand that this is long-term thinking. And again, as a buyer, you don't really know what those charges are when you're making an offer on the property. So if the seller really wants a better idea of what they are, then they might want to order that package from their association ahead of time. And you have You could go into the main part of the condo contract and get waivers of the buyer's inspection and termination rights for these different things, the resale certificate, et cetera, et cetera. Same idea.
Okay, fabulous. So I certainly think that helps clear up, and I know there's been some confusion in regards to this. I know that the Texas Association of Realtors wrote an article recently and published that in regards to the HOA amendment, addendum in regards to what those fees are, what they look like. And I think for certain, if we're going to change language and allow our seller, please, as members of the association, reach out to your broker, have your clients reach out and talk to a title attorney, a real estate attorney that can provide you better dialogue and understanding of these when you are encountering these situations.
Yeah, you really do need help. You shouldn't be making these, even though Kramer's idea of reversing the polarity is great, I want to do it. This is not up to you to decide as a broker. This is a client-driven request. Now, you can talk about your seller with your seller about these concepts and direct your seller to some attorney, and that attorney can direct everybody, and you can be the scribe, where you're just crossing out language under written instructions from your client or your client's attorney. But it can work. There are different ways to make it work in a seller's market, and I promise you this market won't last forever. And when things do change, we'll get used to buyer caps, and it will seem more normal to sellers to accept this burden, if you will.
Burden. All right. Well, Charles, thank you so much for your time today. Always a wealth of information, and I know our membership will certainly appreciate a little bit more clarity to these two documents and assist them in working with their buyers and sellers. Thank you again for your time. I so appreciate it.
Christy, it's been fun. Anytime you need me, I'm here.